So I'm going to get started. I've introduced myself already, but my name's Sue Lukes. I freelance, and one of the things I do as freelancing is teaching housing to local authorities, solicitors, social workers, voluntary organisations, community organisations, etc., specifically around the issue of migrants and housing. I also work on generally around local services and local authorities and migration across Europe. So that's the sort of area I've been working in for a long time. A million years ago, when I had a proper job, I used to run housing advice services for Shelter briefly and other organisations before that. And I was also, just so full disclosure, you know, I was a local authority councillor until last year. So I have seen things from the light side and the dark side. And I'll come on to a bit about local, I mean, obviously we're talking mainly about local authorities here. So please do introduce yourselves in the chat as to who you are and, you know, what organisation you're representing, if at all, where you're working and what your role is. And I'm going to get started. First couple of slides, actually, hopefully. Yes, are basically advertising. So this is the equivalent of where you open the packet of popcorn in the cinema, I'm afraid. This is about who the organisers for these seminars, and you'll be aware that it's organised by Solidarity Knows No Borders. I'm not going to read through all the material on this slide because you will be getting them. And it is just to remind you that we're all here working towards freedom, justice and dignity for all. And welcome to that important work. The political education group is generally a group that tries to work with people, in a sense, working with or for the public, in order to work together to develop our expertise to promote migrant justice. So welcome again to that work. And this is the training series. You'll know that there's over 20 seminars. I think we're about 3 or 4 in now, aren't we? And we're covering a range of areas. I'm sure if there are areas that we're not covering, I'm sure if you contact Solidarity Knows No Borders, then they will see if there's an option for that later on. These seem to be working well and very popular, so we're you know, we're keen to see more of them. I should also mention we've got the chat where we're putting our details on and so on. There's also a Q&A button. As I go through, if questions occur to you, pop them in the Q&A. I will see them. I may choose then to just kind of respond to the question as part of what I'm saying, but also Alia is keeping an eye out, and so she will. Alia's our tech support for Migrants Organised today, and she will make sure that questions don't get left out. You'll also get my contact details on the last slide, so if you feel you want more, then just contact me through that, and I can get back to you on it and so on. Okay, this is Migration Work, whom I'm sort of representing. We are a consultancy organisation, but we're a community interest company. Yeah, well, tagline is that we make migration work for all the communities involved. So we do different things: analysis, training, research, that sort of thing. And we do a lot of knowledge exchange, which is really sort of what we're doing here. Obviously, we're doing this pro bono for today. We do have a large pro bono element, and we also have a trust associated with us, where all our profits go, and you can find out about that through the links here. Getting started on what you come for. Okay, so why are we talking about housing eligibility? So you'll be aware that the hostile environment was basically a set of measures that were put into place over the last 30 years almost, in order to restrict access to a range of services by migrants. And in particular migrants who might have issues with their documentation and so on. And housing was in at the beginning of this. 1996, the first restrictions on access to housing were introduced via the 1996 Housing Act, which reorganised the ways in which local authorities managed and delivered their housing services in terms of access to housing, through the waiting list and so on, and also through homelessness services when people approach and say they're threatened with or physically homeless. So essentially from 1996 it's been the case that only certain types of immigration status and certain types of rights to reside, and only those, in most cases with some exceptions, who are habitually resident would actually be able to get those services. It only covers new tenancies, so existing tenants generally are okay. If they want to move or pass on their tenancy to somebody, or they die and somebody succeeds, generally that's okay. And also the nominations that local authorities make to housing associations. So if you go onto the waiting list nowadays, in most local authorities you may get offered council accommodation at the end of it all, and if you're the tiny percentage you actually get anything out of it, or you may be referred to a housing association for one of their homes. Those nominations are also covered by eligibility. And the other thing it covers is if you turn up at the local authority and say, I am going to become homeless, or I am homeless and I want help, then getting housing through that mechanism is covered by eligibility restrictions. It doesn't cover advice about housing, and that's really important. I hear often of people being turned away by local authorities saying, no, we don't do anything for you because you have limited leave to remain, because you're on a work permit or something like that. Absolutely untrue. First of all, there's a general duty, I'll come on to that in a moment, to provide advice free of charge to anybody in the district who is homeless or threatened with homelessness. And there's also a duty to provide services to private tenants, and that's a duty to inspect their accommodation and to make sure it meets basic health and safety standards, although of course that's often defeated by the landlord then, because they have powers to evict and so on. And there's also protection against illegal eviction and harassment, and those services are available to all tenants resident in the local authorities area. So the housing services we're talking about is the service where the local authority, if they have housing, have to maintain a register, a waiting list for that housing. There are rules about who, about the priorities on it and so on, that it has to take account of the fact that people may be living in insanitary or unsafe conditions. Also needs to give priority to people, in most cases, who are homeless, and people who are overcrowded. And they also have a duty to ensure that only eligible people are on it, and that they only allocate housing to eligible people. You'll be aware that there's a big difference between going on the waiting list and actually getting housing, a difference of at least 90% in most local authorities. So most local authorities just put guidance on that on their websites when they're encouraging people to apply, but they do the big check, if you like, at the point at which people might get tenancies. As I said earlier on, it doesn't cover things like transfers or people swapping, or somebody dying and a child or another close relative who's lived with them succeeding to the tenancy. For homelessness duties, the duties towards people who are homeless, there is this duty to ensure that everybody in the district has access to advice if they are homeless or threatened with homelessness. But the problem is it's a general duty, and so it's quite difficult to enforce, first problem. Second problem is most local authorities see themselves as essentially fulfilling that duty by telling people about services that exist, including things like shelter, which runs a national housing advice service, or Shelter Cymru in Wales. But for those people who go to the local authority and say, I'm going to lose my accommodation, there is a general duty to assist, to assess their need for help, to prevent their homelessness, and if they can't prevent it, to relieve it. But for all of those duties, people have to be eligible. And what they're assessing, the first thing they're meant to be assessing is whether or not people are eligible. So it is the gateway through to those services for homeless people. So, sorry, I'll come back to ways into that if you're not sure about status and things like that. But what we don't have time to do today, because we've only got an hour, is look in detail at who is actually eligible. So what I'm suggesting is really, you just need to be aware that the way eligibility works is it divides every human being on the planet essentially into people who are subject or not subject to immigration control, People who are subject to immigration control have to be in an eligible class in order to be able to access those services. And there are a lot of eligible classes. As you can see, they run from A to P in the alphabet. And they do change quite a lot because the Home Office generally likes to maintain control of that process. And although it would be obvious enough to say, look, if you've got leave to remain and recourse to public funds, you should be eligible, they actually insist that every time they change the immigration rules, then that then has to be written back into the eligibility criteria. So Class P, for example, was only set up in January this year and covers the changes to the law that there's been around victims of modern slavery who now get a specific form of leave under the immigration rules and are now covered and eligible. So it does make for difficulties for local authorities in terms of keeping up with that. And the other side of things, people who are not subject to control. So if you think about, people who might be turning up to a local authority to ask for help, people who are not subject to control generally are going to be anybody who is a UK or an Irish citizen, people who are exempted from immigration control because they have things like diplomatic status and so on. People who are exempted because they're serving in the armed forces, and also the complicated set of categories, people who are covered by EU withdrawal arrangements. These are not people who've got settled status through the EU withdrawal arrangements. They're the people who have got pre-settled status, or the people who are still waiting to sort out their status but have applied for settled status. These are people who have a certificate of application. For all of those people, not for the UK and the Irish people, but for all of the people covered by the withdrawal arrangements, they need to not only have that be covered by the withdrawal arrangements, but also have a qualifying right to reside. And I'm not getting into the detail of that at all. For UK and Irish citizens, the only requirement is that you are habitually resident, and you can be exempted from being habitually resident. At the moment only, the only exemption is because you've been deported or removed from another country into the UK. So if I'm not getting into the detail about how this works, then what I want to do is refer you into the website I co-edit, which is run by the Chartered Institute of Housing and is the Housing Rights Info website. Alia, do you want to see if you can flash that up on people's screens? If you can, that's great. If not, no. Okay, fine. We'll come back to it later, maybe when we finish the slides. So the Housing Rights Info website is one that basically takes you through the different sorts of eligibility. It's divided into two sections. One section is in plain English for migrants themselves to check on where, on their eligibility and what their housing options might be. And the other is the side for people like yourselves who might be advising people and so on. And maybe if there's time, we'll look at it later and see how that works. Okay, so that's if you like where you can find what you need to know about housing eligibility. And obviously the great thing about a website is it's all up to date and easy to refer to and so on. I'm just showing you this diagram because it sort of gives you an idea of the slightly complex nature of the whole thing. It's very kindly done for me by somebody who came along to a training course I did for the Metropolitan Borough Council in Dudley. And she said, I can turn this list of questions and so on into a diagram, and here it is. So you can see if you're subject to immigration control, which is, where it says yes on the left-hand side at the top, then you simply need to be in an eligible class. If you're not subject to immigration control, then for UK Irish citizens and some other people, you need to see what your relationship is to the habitual residence test. For everybody else, it's about a qualifying right to reside and also potentially the habitual residence test. It's messy. It's not easy to follow through on. And I mean, I would say for those of you that might be advocating, be aware that it is quite possible that if you're looking at the Housing Rights website and other reference materials and you think that somebody is eligible but the local authority is saying that they're not, you may well be right. It's not, it's a complex area and one that it's worth advocating for people in and so on. So that's the local authority stuff. For all the other potential rented accommodation, there is eligibility as well, but it's much more recent. Basically 20 years later, the government then essentially introduced eligibility to all the private landlords and also to housing associations that weren't allocating their accommodation through local authority waiting lists. So this was all rolled out in 2016 and covers all adult occupants of new tenancies from that date. So if you turn up to ask a landlord to rent to you and the landlord agrees to do so, they are meant then to check your status. There are exemptions if the local authority refers you because you need accommodation as homeless. If the Home Office is commissioning the accommodation, they're exempt from it and so on. And hostels and refuges and health-related accommodation and so on, and mobile homes. They're all outside of that, and there's no eligibility criteria. Landlords are meant to see people's documents in the presence of those people and keep copies of those documents for a year after the after the tenancy has ended. And they're meant to be identifying people under different categories. They're meant to be identifying people who are relevant nationals, which is UK and some European nationals, generally those with a share code, and people with indefinite leave to remain and shared and settled status. They all have effectively an indefinite right to rent. So once they're in, if you like. Other people who have limited leave to remain or pre-settled status, the landlord is meant to check at the point at which their status runs out to see if they are still eligible. And people who don't have any leave can be given the discretionary right to rent by the Home Office, and that will cover asylum seekers, for example, who might arrive with money and so be able to rent and not need asylum support. At the end of 2016, they amended all the legislation to move it over from being an administrative issue, if you like, to being a criminal issue. So landlords who fail to check or who to rent to people knowing that they failed the checks or fail to check up on people once their leave has run out or whatever, basically become criminals. And they also introduced a procedure which is very rarely used but exists for the Home Office to be able to send to landlords a notification that these people no longer have the right to rent. And that would include not just adult tenants but children in the tenancy as well. So if, for example, your leave to remain has ended and you've failed in your appeals or whatever, technically the Home Office could contact your landlord and say, this person no longer has tenancy rights. And the landlord is then meant to deal with that by, in some cases, if all of the occupants no longer have the right to rent, they can even evict without a court order. It's a massive intrusion into tenancy rights. If it's a mixture of people in the tenancy, then they can go to court to evict all of them, or they can ask the court to transfer the tenancy to the people who are still eligible. So all of that is, quite a significant involvement by the Home Office in the private sector. I should say that my experience, I quite often try and find, private rented tenancies for family members and things like that, is that actually landlords rarely do check people's tenancy status and so on. So the landlords very often don't check. Obviously, landlords at the seedier end of the private rented sector use the fact that the Home Office may be controlling renting in this way, sometimes in order to exploit tenants more, or to control tenants, or to push back on demands for cheaper rents or better conditions and things like that. Also important to note that a High Court case is now due at some point in the European Court of Human Rights, because the decision in the appeal court a few years ago now was that that there was discrimination caused by all of these provisions, the right to rent provisions. It clearly does cause discrimination. There's a lot of research showing that, but that it was justified by the policy aims of trying to reduce access to services by people who may no longer have leave to remain. So the European Court will decide whether or not that justification still exists, if you like, when they get to hear the case. Okay. So that's a fairly grim picture, right? Essentially, what I've said is that a lot of people will find their access to housing very restricted by all of this, and you know, it's not a oh gosh, there's a very good question in here, which is about private renting and legal protection as people eligible to rent. I will come back to that. But essentially, you know, what I wanted to do was just give you some ideas of what, you know, of some things that you can look at. I mean, first of all, there is the fact that housing is generally a local authority, a first-tier local authority responsibility. Local authorities have to have due regard to the need to eliminate unlawful discrimination, harassment, and discrimination, and victimisation, and that applies across the piece to all landlords. So, for example, if a local authority is finding that a housing association doesn't want to take people with limited leave to remain because they're worried about them, you know, when their leave ends or whatever, if the local authority, you know, if they would otherwise qualify for accommodation, the local authority needs to take that up. And they do have a duty, you know, to take up issues of unlawful discrimination. They also need, and you also need to be aware that race is a protected characteristic under the equality duty. Race includes nationality, and that means that very often immigration status is what we call a proxy for nationality. In other words, if you say, oh, well, you know, this hostel generally deals with homeless people, but we're not going to take people on limited leave to remain, you will in effect be discriminating against particular national groups who are more likely to fall foul of that than others. So it is race discrimination. Okay. And I say one of the most important things is that this advice duty that local authorities have to anybody facing homelessness is a duty that must be available to all in the district. And that includes non-eligible people. So local authorities need to be looking at the housing options available to non-eligible people who are facing homelessness or threatened with it. And so they can't just turn people away, in other words. They must make sure that there are services for them, and that may well be services for people who, you know, who have issues about immigration status or limited leave that makes them ineligible and so on. First of all, I think for council housing services, just some things to bear in mind that are quite important if you're working with migrants and advocating for them. First of all, the general duty to assess people's homelessness and so on isn't triggered by proof that somebody is eligible. It's triggered by reason to believe that somebody is eligible. So if somebody has no documents or doesn't have the right documents, and there is no specified form of ID and no specified form of documentation for any of these, you know, types of eligibility, then basically the local authority should not be turning people away, but they should be saying, okay, you know, you've given us reason to believe, you've told us, and we have no reason not to believe you, that you are here with leave that makes you eligible. We will now have to help you to establish your eligibility. And you can't send people away saying, okay, well, you know, we'll put you in overnight accommodation, but you need to come back tomorrow with all the papers that establish it. Actually, local authorities' duty to assist people to establish their eligibility for both allocation and homelessness services. Okay, so that's quite an important thing, because very often when people are approaching the local authority, especially if they're homeless, they often are in situations where they simply won't have the documents because of the ways in which they become homeless. And local authorities cannot turn people away on that basis. I think this is something that really came up during Windrush, because obviously, I mean, sorry, during Windrush, we are still in Windrush, we are still dealing with the fallout from it. But basically, lots of people who clearly the local authorities should have had reason to believe were eligible because they did have indefinite leave to remain because they'd arrived before 1973, or may even have been British citizens, but they didn't have their paperwork, local authorities were turning them away and not accommodating and not assisting them when they were threatened with homelessness because of rent arrears and things like that. And that was clearly wrong. The other thing to note is just that there are codes of guidance that cover both allocations and homelessness. And both codes of guidance are very clear that local authorities will need to establish people's eligibility. Obviously, they'll need to, if the person is physically homeless, they'll need to accommodate them while they're doing that. But actually, if the applicant says, no, I don't want you to contact the Home Office in order to do that, then the Code of Guidance advises that the applicant is then asked to provide other types of proof of their status. And if they decline to do that, then the application is closed. There's absolutely no compulsion on local authorities to contact the Home Office. It's the reverse. The local authority should not be contacting the Home Office unless the applicant consents. That obviously presents a big problem for people who may not have proof of their status, and it may be to their advantage to say, well, okay, go on, contact the Home Office, here's my reference number or whatever, because that may actually establish their status if they're sure about it. But it is important. I think people sometimes worry that they'll be threatened with that. People need to be told that the Home Office should not be contacted unless they consent, and local authorities need to be sure of that as well. Next up, obviously, is what happens if you've gone off and you've got your advice, and your advice is, yep, you definitely, don't have any more tenancy rights here. They're going to get evicted or whatever, but also you're ineligible for housing services. Well, generally, if the applicant or their household includes anybody who is vulnerable, the legal definition of that about people being less able to get or keep accommodation or whatever, or has children, then the local authority should be looking to refer to social services if they're going to lose their accommodation, or their accommodation is wildly unsuitable or unsafe or whatever. But obviously the applicant needs to consent to that. Exceptions are made to that where there's concern for a vulnerable person or a child in terms of protection, obviously. In that case, referrals are made anyway with or without consent. Okay. If people are already in temporary accommodation because they're homeless, so the local authorities accepted that they were eligible, but then they lose their eligibility, their leave runs out, or maybe they lose their EU right to reside or whatever, then they should get reasonable notice to leave that accommodation, and again, another referral to social services. And they won't be in accommodation unless they're vulnerable or have children, because local authorities don't generally have a duty to accommodate other people. Once you're in a tenancy, then the fact that you are no longer eligible actually doesn't affect your tenancy rights at all. And that was a question that came up in the Q&A, so I will just pop into it now, which is, if there's a local authority who are renting privately and are at risk of eviction, can they benefit from the same legal protection as people eligible to rent? And the answer is absolutely yes. They're entitled to exactly the same services. So in terms of protection from eviction and assistance from the local authority, or indeed from the courts in that situation, they should be able to get help and advice from the local authority. Obviously, it's easy enough to say that. In my experience of advising people, most people won't want to go to anything that looks like a statutory service for help. But you should also be able to get help from advice agencies and so on, in terms of advice about your rights against illegal eviction. The problem, as I've said earlier, is that you do have this bottom end of the private rented sector, where quite often landlords are aware of people's vulnerability in terms of immigration status, and so use that in order to increase their power in relation to tenants, given that their power is already pretty extensive. But no, I mean, you don't lose your rights if you're an undocumented family or if you become ineligible at a time, unless the Home Office has sent a notification to your landlord that you are no longer a person who has the right to rent. And if the landlord then wants to act on that, they have to give the Home Office, give a copy of the Home Office notification to the tenant before they start trying to evict them or anything like that. My understanding is that very, very few of these letters are actually issued. A lot of what happened on Right to Rent was pretty performative stuff. It's basically saying we're going to deal with this in the private rented sector, but there are no resources to check on every tenancy or whatever. It's mostly backtracking. I think the Home Office maybe finds somebody who no longer has leave to remain or whatever through a raid or something like that, and then goes back and threatens the landlord with a fine or criminal prosecution if they feel inclined to do so. Last, just notice it's a bit of a peculiarity of case law, really. It's a case from some time ago, and it doesn't often happen. But if a person is eligible, but they don't have access to benefits or other means of paying for their rent, then local authorities, if they accept somebody as homeless because they are homeless and they're in priority because they have a child or a vulnerable person in the household or whatever, needs to provide accommodation at a peppercorn rent. They can't turn people away because they can't pay the rent. Now, I actually think there are very rare cases where this actually happens really, in the sense that mostly eligibility for homelessness services and so on is aligned with benefits. But what often happens is the DWP get it wrong. And so they're refusing benefit to somebody, especially around issues of right to reside and European people, with pre-settled status and so on. So if the local authority comes to its view that a person is eligible, they will need to provide the accommodation regardless of the DWP's inclination to pay. Okay, I've got a couple more questions here. Gosh. An anonymous attendee here has said, just referring back to issues about eligibility and proof, no, it's not reasonable to request somebody's original documents rather than a copy. Then, the issue is, if there is proof available. So clearly, if somebody had a BRP, for example, then it would be quite possible that, with the copy of the BRP, with the applicant's consent, the Home Office can be contacted and confirm the validity of the original biometric residence permit. And so there's no reason at all not to accept that person initially into accommodation. As I said, there's no sort of specified proof. It's not like trying to go to vote. There isn't a list of documents that you need to provide. It's actually that the local authority needs to establish the identity of the person in front of them and their eligibility. And that can be provided by all sorts of things, not just by an original document. If there is an issue about the applicant's credibility in other areas, then that's something different that would need to be contested as part of the advocacy you're doing. So I'll just double check the questions before I move on. Good practice, local authorities going beyond their statutory duties in housing people with no recourse to public funds. I would say there is the no recourse to public funds network that essentially, promotes good practice amongst local authorities. And it's worth looking at local authorities that are in that network. I think maybe I'd like a little bit more detail on that question to just sort of establish what it is you want out of that. In terms of statutory duties, if people are homeless and have somebody vulnerable or a child or a pregnant woman in the household, then if housing authorities can't actually accommodate, then in most cases social services will need to do so, and there needs to be a referral done on that. But my contact details are on the last slide, so I'd love to know a bit more about what you want. And there may even be some things on the later slides to tell you about that. Other things that are good to know. First of all, human rights do count. Local authorities do actually need to have regard to human rights. And there is a very basic human right against inhuman and degrading treatment, which can be used in some cases. And it's worth considering that and getting legal advice on it in certain circumstances. During an emergency, and of course we've had a good run on emergencies in the last 3 years, local authorities can accommodate people who are ineligible. They have powers to do that. Normally those powers mean that you can't do something that is, if you like, prohibited by other legislation. In other words, accommodate ineligible people. But when there's an emergency, you can. There's case law on this. and they can use various different powers under the Local Government Act. Or they can use the powers under the NHS Act in order to avoid danger to public health. And that obviously was what we had during the pandemic, and that was what the basis on which local authorities accommodated many people who were street homeless and so on, and many of those were ineligible migrants. Okay? I mean, this is a long slide, and I'm not expecting you all to read it on your screens right now, but get the slides when they come back out to you, and we'll and read this. It's an interesting bit of case law. It covered benefits. It's very recent. Okay, you can see it was towards the very end of last year. And basically this covers people who are covered by the EU withdrawal agreement. So that's all these people with, you know, pre-settled status and people with certificates of application because their settled status hasn't been agreed yet or whatever. And basically Britain signed up not just to the withdrawal agreement, but also as part of that, to the EU Agreement on Fundamental Rights. And one of those fundamental rights is that human dignity is inviolable, it must be respected and protected. Okay, so what this case was a woman who had fled violence, domestic abuse, with a small child, so she couldn't work. She had not entirely sure why, not been able to get help from social services. I would have thought they should have done, but for whatever reason, she didn't. And so she applied for universal credit. The DWP said you're not eligible because you don't have a relevant right to reside. And the tribunal said, wrong. This is the upper tribunal. You're wrong because you have to respect human dignity. And you can't do that if you fail to provide the basic needs, a place to live, food, clothing, and personal hygiene, such that it would undermine his or her physical or mental health or put them in a state of degradation. Okay, so this is potentially an option, again, to try and enforce housing rights. And I mean, that might be via social services or it might be via housing authorities. And we don't yet know because I think everybody's looking for the cases to take to local authorities and see, because this is case law as it develops. But we have not only human rights, but fundamental rights covering people who are European nationals and their family members and so on, all covered by the EU withdrawal agreement. Oh, good, right. That was, I thought I'd finish on the last one because I think actually, even though it only applies to some people, the fact that we have people in the UK whose fundamental rights are guaranteed is something to at least cheer us up. If you want to see more people whose fundamental and human rights are guaranteed as migrants, then do please, you know, join in Solidarity Knows No Borders and get in touch with them and join in the other seminars and so on that we're going to do. And if we have the next slide, I think this is also advertising, the next one. Yes, there we go. So my sort of advice is, first of all, if you're looking to try and you know, do something about housing, migrants' housing rights, first of all, do remember the website. It's there, it's also in the chat. And it's basically a source of information that is kept up to date. I co-edit it with various colleagues and we try and make sure that it has the sort of maximum amount of information you can use. There's also a quarterly newsletter that comes with it if you want it, an e-newsletter that, you know, gives you updates on good practice and things like that. Yes, we've got some councillors on the call, I think, and I would just say one of the things I'm doing is that when I was a councillor, I became the first migrant champion councillor in the UK. We now have a network of migrant champions across the UK. It's a multi-party network, a cross-party network, and we are all committed, if you like, to advocating for migrants' rights in our local authorities. And if you are in touch with any local councillors, get them, you know, to join the Migrant Champions Network, and ideally get them to get themselves nominated as migrant champions within their local authorities. We've got a letter out on asylum accommodation, which we'd encourage you to, you know, to get your local councillors and so on to sign. We've got 200 councillors signed up to it, and we're going to go public with it very soon. So you have a little window over the next day or so to do that. Find details on our website, migrantchampions.org. Talk to us at Migration Work about consultancy, research and training, and in particular, if you want to organise training on eligibility in your local authority or other service or whatever, you can find me, Sue Lukes, at Sue.Lukes, sorry, at migrationwork.org. Okay, so that's pretty well it. I'm going to come back into questions. Sorry, I find the seminar format difficult because I prefer to see people and have people shout at me and wave or even throw things if that's what is your inclination. So please, now is your chance to put stuff into the Q&A in terms of picking up on anything that you've seen that you wanted me to answer or to respond on. First, the question I've got here, which is really interesting, is what sort of people typically do you see excluded from housing eligibility? What sort of immigration status and gender? Okay, the simple answer to that is it's anybody. In terms of immigration status, that's how the rules work. So the people who get excluded from local authority housing eligibility are anybody with limited leave to remain. That includes a bar on recourse to public funds, and anybody, any EU citizens who don't already have settled status or pre-settled status and what's called a qualifying right to reside, mostly covered by people who are or have been working and their family members, and the self-employed and students and the self-sufficient. So people who maybe have, like the lady who was subjected to domestic abuse and so had to leave the relationship she was in, which meant she was no longer a family member and couldn't work because she had a small child and was traumatized. Those are the sort, I mean, so people fall out of eligibility because they lose their status or because their status changes. And given that a very high proportion of people in terms of recent migrants are here on limited leave to remain with no recourse to public funds, because since we left the EU, work migrants are, in significant numbers here on work permits and so on. They're all out of housing eligibility as well. I'm not sure that there's necessarily a kind of obvious group of people. I think the people who, if you like, are affected most by it are inevitably people who are vulnerable, or sorry, not vulnerable is the wrong word. I mean, yes, of course, more women than men are affected by that in terms of needing to go to councils for housing because they're less likely to have access to an income, less likely to have jobs that will pay enough to pay rent and childcare and so on. So there's clearly a lot of gender implications in all of that. But the rules are there simply to exclude specific types of status, or of course people with no status at all. And I think it's fair to say that we don't really know who ends up as undocumented. We see the people we see, but there are a lot of very successful undocumented people as well, who we don't necessarily see coming into, to ask for help and advice and so on. Sasha has devolved powers. You're absolutely right. Essentially, people seeking sanctuary who are living in Wales are generally going to be people who either already have refugee status or the various special statuses given to people from Ukraine and things like that. They generally are eligible. People who are asylum seekers are not. As we know, they're meant to be dealt with by the Home Office through the asylum support system. And I would say I'm interested in that conflict between nations with devolved powers, Scotland and Wales in particular, and the Home Office, because generally I think there is a real tension. I think if you want to eradicate street homelessness, you are going to have to lose conditions about eligibility, because otherwise you do find that migrants are disproportionately represented amongst the street homeless precisely because they are not eligible for other services and so on. So that's that is an issue that devolved governments are going to have to grapple with. I really don't know why they don't push back a bit more on eligibility in particular, and certainly in Scotland in some aspects they seem to have sort of gone slightly out of line with the English legislation, but in Wales, they seem to generally line up usually a little bit later, a month down the line, they'll pass the same eligibility regs as the English. And I think there's potential for Wales to think about going its own way on that. And I'd love to discuss it with anybody who fancies working on it, because I think there's real possibilities there. There's a follow-up. How much do the council enforce discharging the homelessness duty when people lose their status? The problem for councils on that one is quite simple, which is, as I said, mostly housing eligibility lines up with benefit eligibility. So typically, for example, if you have a European citizen who was working and so had a relevant right to reside, and then they're in housing, they're in local authority homeless accommodation, and they're sacked because of misconduct from their job, that they would not only lose housing rights, but they would also lose benefit rights in some circumstances. There are ways back in through the rights of children in education and things like that, which I won't try and explain in the tiny amount of time available, but do get back to me if you've got a case on it. sue.lukes@migrationwork.org. Just send me stuff and I'll get back to you. But generally, it's a bit like when people are found to be intentionally homeless. If they're in accommodation already, they'll give them reasonable notice. But the problem for local authorities is those people will also not have access to benefits. So unless they've got savings, they're going to struggle to pay the rent. So local authorities are not inclined to keep them on for very long. Someone here is talking about EU citizens. A lot of people are refused access because they can't prove their status. This is from Vi. Sorry, it's in the chat rather than the questions. I would say absolutely, and I think it's a huge problem. I think the whole settled status exercise has left large numbers of vulnerable people out. I think there's a lot of people who didn't realise that they needed to apply. A lot of people didn't apply for their children who are now turning 18 and adults in their own right. Interesting, a lot of older people and people who've been here a really long time didn't apply as well. A lot of people thought, oh, well, here I am, I arrived from the Netherlands in 1960 and I've been married to my British husband for most of that time. I don't need to apply, but actually they do. So when things get difficult, it's just like with Windrush. When you then need to apply for particular services, that's the point at which it turns out that, you do need those documents and so on. The only thing I would say is that the Home Office is still accepting applications. Yeah, absolutely. Yes, you're right. 1960. I should have said 1975, shouldn't I, or something like that. The only thing I would say is that there's still good cause for late applications to the Settle scheme. And so people can actually still apply if they simply were unaware of it, particularly if that's because they were vulnerable in some way, or maybe being held back in some way because of their domestic situation. Maybe people who are victims of domestic abuse or exploitation within the family and so on. They can still apply to the Settle scheme, and they will get a certificate of application. And then as long as they've got a qualifying right to reside as well, which may be difficult for the more vulnerable, they will then be able to to access services. But of course, we're also looking at the EU Charter of Fundamental Rights on that. So I thought I might finish on that since there's no more questions. And it's one of the nicest things I've seen recently, which is, people who can't work for whatever reason may like to look at the EU Charter of Fundamental Rights as something that might guarantee them their dignity, which is what it's designed to do. Sorry, Alia.
No, I just wanted to sort of, maybe the final question is to go back to Katya's question about the examples of good practice, because she put in the chat that she's aware of the Greater Manchester ABEN scheme, a bed for every night strategy, guaranteeing 10 beds in emergency accommodation for people on NRPF. And so she wanted to hear about other local authorities that are doing good work. So if we could end on that.
Absolutely, yes. London, the Greater London Authority and the Mayor have similar schemes, with beds available for people with no recourse. And I mean, I as I teach local authorities and do encourage them to get training on this if they can, and there's my contact details in the chat if you need them. I would just say that as I teach local authorities, you do find that lots of local authorities, consciously or not, you know, in effect, just say, okay, well, of course, you know, we'll put him in the hostel. We know he can't pay or whatever, and then end up supporting people. I think the whole exercise of everyone in over the pandemic has made local authorities aware of the fact that they had a lot of street homeless people who were defeated, if you like, by their status as migrants from accessing services, and are now grappling with the problems of how it is you get them back into services. I was asked about a case recently where the guy clearly has been in the UK for almost 20 years and street homeless for much of that. How can you share good practice? Okay, well, our our Migrant Champions Network tries to do that, and I think you'll find quite a lot of stuff on the NRPF network website. Homeless Link also shares a lot of good practice and has a route map to getting, you know, to abolishing street homelessness in terms of getting migrants into accommodation and so on. And that also, I think, is looking at it. Oh, here we go. A late question. 1 minute to go. Applicants in hostels who are victims of domestic violence, trafficking, etc., who face harassment. Gosh. You know what? I'd love to talk to you about this and think about ways in. I think essentially, I mean, if people are in temporary accommodation, thank you. If people are in temporary accommodation, then, you know, that accommodation has to be suitable. And if they are facing harassment in it, it's unsafe for them. And so the argument would simply be that the local authority has not placed people in suitable accommodation. I think, unfortunately, you might then need to take legal action on that if the local authority is not responding to requests for help and so on. Obviously, if you have a migrant champion in your local authority, and if you don't have one, you really should have, it's the sort of cases that migrant champions take up, those sorts of things. So, you know, it would be really helpful to promote that and see if your local authority or local authorities can establish a migrant champion who can then, you know, pick it up as casework and see what the problems are where migrants are not accessing the rights that they have. Okay. Are there any more? I hope that's answered that question. I'm ticking the answer live. I've got no more open questions here. And I'm not seeing, okay. People have my email. It really is an invitation to get back to me. I mean, it's a great help to know what's going on. It's always interesting to be able to see what cases, and of course I can find organisations and so on that may be able to work with you on it if necessary. So please do get back to me if you can. And thank you very much indeed. I wish I could see you all. I find the panel format difficult in that sense. And I hope you have a good rest of the evening. And thank you very much. It's been a privilege to be with you. Thanks.